All right, thank you, Ashley. Good morning, everyone. Thank you for joining us for the Zoning 101 session. I'm Jennifer Gilbert, Director of the Office of Planning and Development at the Department of Business and Economic Affairs. And joining me in this presentation is Stephanie Verdile and Noah Hodges, both principal planners, and the two most likely you're going to be talking to if you inquire with our office about planning and zoning questions. All right. So just a quick overview of what we'll be talking about during our session. We're going to start out with the purpose and history of zoning, talk about some zoning basics, the nuts and bolts of the zoning ordinance, relationship of the zoning ordinance to other land use regulations, state preemptions and local land use control, future zoning in New Hampshire, tools and resources for communities, and then we'll have time for questions and answers. But we will be taking questions and answers in between some of these topics. All right, so we are the State Planning Office. In case you missed the welcoming, which I already provided some of this overview already. Over the last 20 years, you've probably noticed that we've kind of changed our names over the years. Last year was the last time that we've changed. The planning division of Office of Strategic Initiatives was transferred to the Department of Business and Economic Affairs. So now we are a part of a larger agency that is dealing with the very similar topics that we deal with, and gives us a great opportunity to work with more of our colleagues at BEA. All right, so Office of Planning and Development, we have 6 planners and we have 4 main programs that we administer. We provide a lot of technical assistance and training on planning zoning topics, floodplain management, and census data. For our training, we have an annual conference every spring, which we hope to bring back in 2023 as an in-person meeting, along with some pre-recorded sessions, which will be available online. Since 2021, monthly plan webinars. We've been doing every third Thursday of the month at noon. Our next one is next Thursday on the 20th, and that's getting ready for town meeting. Stephanie is going to be doing that one. So if you'd like to join us, please reach out to us and register if you haven't already done so. Resources, we have a lot of resources online. We are still under our previous agency's Office of Strategic Initiatives website, but we hope to transition to that. Our new one, hopefully before the end of the year, and we will certainly let you know when that happens. We also produce a lot of maps and data. Some of the most recent data that we've produced is the population estimates that we do every year for state municipalities. We also just released the 2020 to 2050 population projections, which is also for state municipalities, and that is also done online. All right, slide. All right, so to kick off our session, I'm going to just give a brief overview of the purpose, what is zoning, and the history of zoning and how we got to where we are right now. All right, I'm going to start with a quote. This is from Peter Laughlin from the New Hampshire Practice Series, Land Use Planning and Zoning. Zoning increasingly tempers the ancient property law maxim that ownership extends from the surface downward to the center of the earth and upward indefinitely to the skies. Through the application of zoning law, courts have increasingly recognized that common law right must be balanced with the rights of property owners as they are protected or restricted through zoning. So that's just to get us started thinking about what exactly is zoning and what is its purpose. Okay, next slide. So before we get into zoning, I do want to point one thing out, and we'll be discussing this throughout the session, is that zoning is not planning. Zoning is actually just one tool of the planning toolbox. So we'll be getting into that a little bit more, but just wanted to point that out before we get started here. All right, so the purpose of zoning is regulating the size, location, and use of buildings and other structures for the purpose of promoting the health, safety, and general welfare of the community. It regulates how things are allowed to do, what you're allowed to do on a property. It organizes how land may be used It establishes an orderly pattern of development. And in summary, zoning regulations do two things. It regulates use and it regulates the density of the property. The regulation of zoning is usually done in two documents: the zoning map, which assigns every parcel to a zoning district, which dictates the uses allowed in the district. Then there's the zoning text, or the zoning ordinance. It details what you can and cannot do in a zoning district. And I think Stephanie is going to be getting a little bit more into detail about that. But we have what's called traditional zoning, which is dividing the municipality up into districts with the goal of separating what are thought of as incompatible uses. There are generally three principal uses of zoning: residential, commercial, and industrial, but obviously there can be more. In each district, some uses are permitted as a right, some are prohibited, and others are allowed only by special exception or conditional or special use permit. Then there's something that we call modern zoning, which encourages mixed use zoning, in which residential and commercial uses are permitted in specified districts. Zoning may also impose requirements on a specific use, such as size and position of signs and special setbacks or screening for junkyards. Included on this side is RSA 674-16, which details the grant of power that gives New Hampshire local communities the power to adopt or amend a zoning ordinance. It details how the zoning ordinance shall regulate and restrict. As you can see, it talks about how zoning ordinance shall be designated to regulate and restrict the height, number of stories, size of buildings and other structures, lot sizes, the percentage of a lot that may be occupied, the size of yards, courts, or other open spaces, the density of the population in the municipality, and the location of use of building structures and land for business, industrial, residential, or other purposes, as I've already discussed. All right, so we're going to get a little bit more into the history of zoning, specifically in the United States. So early planning in the US is seen as a system of land grants and westward expansion in the Midwest. These land sales were really the first subdivisions. They were 36 square mile townships that were subdivided into 36 lots. During the Industrial Revolution, planning was done by corporations to create industrial economies. This was including factories, commerce, employee housing, and recreation. Many of our mill towns around New Hampshire are great examples of what occurred during this time. So what was life before zoning? There were limited restrictions on what property owners could do on their land. In the late 19th century, population growth and technological changes began to change things across the country. There was transportation technology that began to change how people got places and where they lived. Transit systems, electric streetcars, and automobiles started becoming available to the general public and changed how people got around. They no longer needed to live in the centers of the cities to be near work or services. They could actually move farther out of the cities, which is what we know today as the suburbs. Building technology also changed how buildings were built and increased the density of these properties. The first steel frame building, also known as the first skyscraper, went up in Chicago in 1885. These steel frame buildings removed the structural loads that limited how high our previous masonry structures could be built to. Steel frame structures could now rise 10 stories or even higher. Elevator technology also advanced at the same time to allow access to these higher levels. Cities were now seeing these taller buildings and more floor area, therefore more density per property than they had ever seen before. In addition to this time in the US was experiencing devastating fires and other disasters in cities, and many buildings were being destroyed or damaged. In particular, in New York City and other major cities, population growth was causing cities to be overcrowded due to significant demand. Housing was starting to not be available. And so there was a real effort to really meet this demand, and houses were being built at minimum standards, which ultimately led to some concerns about health and safety. One way to address this was the Tenement House Act of 1901 in New York City, which established housing standards which were enacted in a series of health and safety-oriented restrictions for residential buildings. Then in 1914, in New York City, a committee came together to address the traffic issues. As I mentioned before, technological advances resulted in the transition of horse-drawn carriages to automobiles. In addition, all those tall buildings in New York City were affecting the air and light onto the shorter buildings and onto the city streets. So they knew that they needed to do something. So in 1916, New York City developed the first comprehensive zoning ordinance. It was 14 pages and it included 3 sets of maps. It established different zoning districts and height, area, setback, and use restrictions pertaining to each district. This ordinance became the model for urban communities across the country and began the wave of comprehensive local level zoning across the country. New York City at that time was an established city. In contrast, Berkeley, California was a young suburb that was expanding a lot due to population growth. Berkeley's first zoning ordinance first introduced single-family zoning district in the US. Other zoning ordinance at that time had very broad residential districts, which included single-family and multifamily within that district. Berkeley's traditionally zoning ordinance had hierarchical zoning, which meant that less intense zoning, such as housing, was allowed in more intense zoning districts, such as where factories were happening as industrial. But you couldn't go vice versa. Nothing could go into the less intensive ones had to be reserved just for housing. But Berkeley introduced flat zoning, which restricted each district to its own designated use. So housing couldn't go into industrial as it had done under the hierarchical zoning. Housing had to stay in the residential districts. So that was a change that certainly happened in Berkeley. In 1922, the Standard State Zoning Enabling Act was established by the US Department of Commerce. They drafted model law for states to enable zoning regulations in their jurisdiction. At that time, 48 municipalities across the country had adopted zoning at this time. The act established the basic process of zoning, but it didn't include any details about the content of the regulations. New Hampshire adopted this model in 1925 with very little changes. It actually remains largely the same today as it was adopted back then. This act, along with federal incentives, led to an increase in the adoption of zoning. By 1936, 1,300 municipalities had enacted zoning in the United States. The first constitutional challenge to local zoning happened in 1926 with Euclid versus Ambler Realty Company. Euclid, Ohio's zoning ordinance prohibited industrial uses in certain districts. A 68-acre property owner filed suit, claimed that the zoning law deprived him of his property, which would be more valuable without the zoning ordinance. A federal district court found that Euclid's law unconstitutionally, or in other words, violated the 14th Amendment of the US Constitution, which deprived him of liberty without due process of law and denied him equal protection of the law. It then went to the US Supreme Court, which ruled that the enactment and enforcement of zoning laws was a proper application of the police powers that resided in the individual states. This court ruling gave zoning its first stamp of approval. Following that ruling, Euclidean zoning, which is the separation of municipalities into different districts, where certain land uses are permitted or prohibited. Here in New Hampshire, the first zoning ordinance adopted in New Hampshire started with Manchester in 1927. It was followed by Keene, Nashua, and Concord. New Hampshire's first constitutional zoning challenge happened in 1928. This was related to a landowner in Manchester who challenged part of the city's zoning ordinance, that it was unconstitutionally infringed on his property rights. The New Hampshire Supreme Court cited the Euclid case and upheld the constitutionality of the zoning ordinance. It was now at this point that both the state and the federal courts had ruled zoning as constitutional. There were many, many more federal and state court cases that have occurred since these two cases, which have shaped what zoning is today. As you can see from the slide from RSA 674-17, these first few purposes items that are listed in the statute kind of go back to those issues that cities and towns were dealing with in the early 1900s with overcrowding, fires, and health issues. The purpose of the zoning is to help lessen the congestion, secure safety, promote health and general welfare, protect that adequate light and air that those tall buildings were impeding on, and to prevent the overcrowding of land as populations grew. On the next slide, the last few items that are listed in the statute kind of more align with more of the modern purposes of what we enforce in zoning ordinances. From providing adequate transportation, solid waste, protection of natural resources, and then at the subsection J, it's the installation of solar, wind, and other renewable systems. So to conclude this portion, I just wanted to leave you with some stats of the current status of zoning ordinances in New Hampshire. Currently, 226 municipalities and village districts have a comprehensive zoning ordinance. 19 municipalities do not have a comprehensive zoning ordinance. However, 13 of these have some type of zoning, whether they've adopted a floodplain development ordinance and/or have developed a telecommunication ordinance, which leaves us with 6 without any other type of zoning ordinance. That concludes our the purpose and the history of zoning. So I'm going to move on to Stephanie, who's going to kind of get us into more of the zoning basics. Ashley, do we have any questions so far? Are we good to move on with Stephanie?
I do not see any questions so far.
All right, great. Well, thank you. And here's Stephanie.
Okay, can everybody hear me? Can you hear me now? Can you hear me now? Okay. Good morning. I'm Stephanie Verdile. Thanks for joining us. Thank you, Jennifer, for the introduction. You know, a couple of things that if you'll find out through this presentation is that, you know, there is going to be some repetitive, you know, comments, some repetitive thoughts here. And it's kind of just part and parcel when you're dealing with zoning, when you're dealing with planning. There's a lot of dovetailing and there's a lot of other issues that relate with zoning and planning. So forgive us for sounding like we're repeating ourselves, but, you know, broken down, they really are, you know, integral to the part of zoning that we're going to be reviewing. So next slide, please, Noah. So as Jennifer mentioned, you know, she touched a little bit about, you know, what is zoning and planning, and that zoning is not planning. So, and we seem to use these terms, you know, interchangeably, and we just want to kind of set the stage that while they're very similar, there are a few differences. And so I'm just going to explain a little bit about what the difference between zoning and planning is. Zoning is the legal process, as Jennifer had mentioned, but again, we're trying not to be too repetitive, but it is part of how we're explaining the whole process. So zoning is the legal process for regulating the type, location, density of land uses through regulations and documents. And planning is the legal decision-making process in which communities' goals and objectives for deciding future land uses are established through regulations and planning principles. So both planning and zoning are community-based. Both planning and zoning regulations are community-based. And so what that means is that individual communities are given the power to decide whether or not they want to have land use regulations in order to determine and guide future development of their communities. Both are considered community-based, planning and zoning, meaning that, again, the communities came forward and decided that this is how we want our growth to go in our community. This is where we want uses, where we don't want uses. So both are considered the regulatory framework. Again, when you have the differences and the similarities between planning and zoning, zoning is really the regulatory avenue for how a community wants to move forward with guiding development in their community. And planning is the implementation of that, the planning goals, the planning principles. And when you have those types of zoning and planning, you get into land use regulations. So generally speaking, the zoning ordinance and the planning regulations, everybody knows them as zoning ordinance, subdivision, and site plan regulations. Again, there's other regulations that the planning board are in charge of, but for the general discussion here for zoning 101, the main types of regulations that a community agrees to adopt and enact in order to set the development principles and have guiding development principles for their community is through the zoning ordinance and through the subdivision and the site plan regulations. Next slide. Thanks, Noah. So having said that, what is zoning's relationship to the master plan? So as you all know, now the master plan, as I like to say, is at the top of the food chain. Okay, the master plan is the legal building block for land use regulations. And as the RSA, governing RSA 4 of the master plan says, the purpose of the master plan is to set down as clearly and practically as possible the best and most appropriate future development of the area under the jurisdiction of the planning board. To aid the board in designing ordinances that result in preserving and enhancing the unique quality of life and culture in New Hampshire, and to guide the board in the performance of its other duties in a manner that achieves the principles of smart growth, sound planning, and wise resource protection. So as you can see, the purpose of the master plan is this all-encompassing that a community votes to adopt a master plan, then that's what sets the stage for the rest of the land use regulations. It's about the development of the area under the jurisdiction of the planning board. The planning board is driving the bus for that community based on what the community said they want for development and how they want development of their community. The master plan is the legal standing and implementation of additional land use regulations. And again, the master plan is also community-based, okay? That means that the master plan is based on the goals and objectives that the community said they wanted. And when you have a master plan, the bare necessities are the land use chapter and the vision chapter. So it's kind of self-explanatory. A master plan's vision is the vision of that community and how they would like to see development, where they would like to see development concentrated in their community. And the land use chapters are what types of development they would like to see in that community. So the master plan at a bare minimum, in order to help regulate how a community grows through zoning and through land use regulations, is based on the vision and the land use chapter. Now, there are other chapters that are outlined in the RSA that a community can definitely choose to adopt, whether that's transportation, community facilities, recreation, housing. That's all, again, community-based. The communities decide on an individual level what types of chapters and land use requirements, all those kinds of things are what the community wants in and of itself. So what Salem may want is going to be much different than what Littleton may want. So you're not going to have these homogeneous master plans and zoning ordinances and site plan regulations. They all when we talk about community-based, that's what that means. So in order to start the process for getting a master plan, for getting your land use regulations, for implementing your master plan, is that you first have to have a planning board, which again is something that the community chooses to do and vote upon whether or not they want to have a planning board to take care of the development and guide the community. The planning board's first order of business is they have to have their own rules. As we all know, you have to have your bylaws. So once the planning board adopts their bylaws, then they move into the master plan. Again, community-based. It's their job to solicit input from the community and take those suggestions and community input and put them into the chapters to create and implement the master plan. Once the community has adopted a master plan, again, the planning board is driving the bus, and they can, given the authority, can adopt subdivision regulations. So again, that's community-based. If the community said, we want residential development down by the river, then those subdivision regulations need to reflect that. Once you finish with the subdivision regulations and moving on further is the adoption of a zoning ordinance. And again, as we've talked about, a few times already, is that zoning is the legal standing that gives the community the ability to say, yes, you can have residential development down by the river, you can have industrial development out by the highway. That's the avenue that gets these communities to how they want to plan and guide development in their community. So you have your master plan, you have your subdivision regulations. The communities can move further on to develop their, amend and adopt their zoning ordinance. And then once you get from the zoning ordinance, then again, it's back to the planning board where they can adopt site plan regulations. So as Jennifer mentioned, there are a few communities in the state that don't have zoning. And one issue to keep in mind for communities that don't have zoning is that the community is not able to review, comment, decide or not decide on site plan development, which is multifamily commercial industrial development. So in order to have the all-encompassing community involvement and community direction as to where and how much and what kind of development takes place in your community, you need all those steps: the master plan, the zoning ordinance, the subdivision regulations, and the site plan regs. Next slide, no, thanks. So there are two kinds of zoning ordinances, basically two styles, I guess I should say. And permissive zoning is if a use is not specifically identified as a permitted use or a use permitted by special exception, then that use is not allowed. Usually it's guided or it's identified by having a specific table of permitted uses. So what that means is that if my community doesn't allow a nuclear power plant as a use, then I can't have a nuclear power plant as a use. Prohibitive zoning are list uses that are not permitted. So it's presumed that any use that is not expressly prohibited is permitted. So if another community does not list that nuclear power plants are not allowed, then they are allowed. So it's a little confusing, but you have to kind of really understand. And one of the big giveaways, obviously, is that if the zoning ordinance has a table of permitted uses, or if uses are listed within each district, then you can pretty much go along with the fact that that is a permissive zoning ordinance, which probably is a little bit user-friendly. But prohibitive zoning ordinances are some of the earliest ordinances, and there still are some that are, on the books kicking around out there. Next slide, please. So as Jennifer mentioned, there are usually like two components, I guess, when we talk about zoning. Again, we use these all-encompassing terms of zoning, but then we have to split them up a little bit and split up the hairs. So it's generally accepted that there are the two components. You have the map and you have your ordinances and your regulations. Your zoning ordinances, it's kind of like your town's rule book. Okay, so this is what you can do and can't do in your town. This is how you do it. If you want to have a home occupation, these are the rules for that. So it's how the municipality decides on how they want their growth and development to go. And you need rules. Like Kramer says, if we don't have rules, we have chaos. So the RSAs that enable communities to do that are 674, 16, and 18. And again, the municipality decides. It's community-based on whether to adopt zoning to be able to have that ability and power to control the land uses and the development within their community. Then you have your zoning map, the map that, again, geographically shows all the zoning districts and boundaries and classifications as described within the zoning ordinance. So you have your rule book and you have your map. In order to carry out the abilities and the powers and duties to have zoning, RSA 674 is what kind of helps describe the purpose of the map. In order to carry out and accomplish the purposes of zoning, the local legislative body may divide the municipality into districts. So and usually they're color coded, as you can see, there's islands there. So that's their own district. The map is showing that zoning on those particular pieces of property are different than the other pieces of property throughout the community. Next slide, no, thanks. So you have a zoning ordinance and you need to make some changes. So again, the first step in zoning amendment process is through the planning board. They are driving the bus. They're responsible for initiating, for holding the public hearings and moving the proposed amendments forward for a vote by the legislative body. Zoning amendments can come to the planning board in 3 ways, initiated by the planning board. The governing body may submit zoning amendments, and there's also the petition zoning amendments that all move forward to the planning board. So you're the planning board, it is the season, it's zoning amendment time again. What is the process? What should planning boards be doing, or communities should be doing to get ready to make changes to the zoning ordinance? You know, one of the things that I always recommend is that I think it's really important for the planning board, planning staff, zoning administrators, building inspectors, code enforcement officers, ZBA, we should all kind of be aware of what's going on with each other's boards. If there are a lot of special exceptions or a lot of variances from a particular section of the ordinance, then it may be worthwhile for the zoning board and for the planning board to talk about that and see if there's any changes that can be made to the language in order to reduce the number of special exceptions and variances. It's important to talk to other municipal boards and staff about the zoning ordinance. So again, this is your town's rule book. And if you have got the Conservation Commission that's looking at, you know, the wetlands ordinance, for an example, in your zoning ordinance, and there's language in there that's confusing to them, or maybe they are, you know, proposing to make some changes, or whatever the case may be, it's important that all boards communicate and you all try to make the best rule book that you can with language that is understandable and easy to interpret for everyone. So it's important to work with other board members and staff. 2 of my favorites, you know, review the table of permitted uses and definitions. You should be having definitions that have a use listed in the table. And if you have a use listed in the table, you should have a definition. So if you, I want to open a doggy daycare, and I don't have a definition of a kennel, or I don't have any type of definition of that, but then I have the use in the use table, that it's a little bit hard for staff and for the public to kind of work with something like that. So just make sure that go through, do, you know, a cursory review every year, a couple times a year, or if there's things that you're encountering, there's all of a sudden a rush for doggy daycares in your community, and you don't have that defined, and you don't have it in your table of permitted uses. So in essence, without those, these people are going to the zoning board for variances. So that's part of the whole cog of the wheel, is that if we're getting too many requests for variances based on something in the ordinance, then maybe we need to change that section of the ordinance. For every action, there's a reaction. So when you make a change to the zoning ordinance, actually before you even go through with the finalization of it, I would suggest that you do another review of your other land use regulations. So if you have a definition of a multifamily development or multifamily dwelling in your zoning ordinance, but then in your site plan regulations, that definition is different. It's not anything that's going to make it easy for boards and staff and the public to work with those kind of conflicting definitions. So just once you change something in one ordinance, just kind of make sure that you're following through and the uses or the definitions and words are similar. Most zoning ordinances probably have some types of reference to state RSAs, the Comprehensive Shoreline Protection Act, 155E. I would recommend that you put into your ordinance, if you're citing those types of state regulations, that you put, you know, we adopt these excavation regulations per 155E, add the language as amended, because that way your ordinance will stay up to date with state law amendments. And so you wouldn't have to worry about, 155E gets amended, but next thing you know, your ordinance and your regulations are kind of out of date. So let's make sure that it's an easy thing. It's a housekeeping thing that you can do. It requires very little explanation. It's just to make sure that your zoning ordinance keeps up to date and prevents you from having to go back and amend your zoning ordinance just because the state has amended their RSAs. Next slide, please. No, thank you. So how do you do a zoning ordinance amendment? We all know in towns, it can be adopted only at a town meeting or a special town meeting, and that's once a year. They get one shot at the apple to amend their zoning ordinance. In cities and town councils, and however the municipal charter dictates to them, they can be done at any time of year with the cities. So they have this distinct advantage over towns to be able to keep their zoning more up to date. Maybe a city is going to adopt form-based code and they find out, 4, 5, 6 months later that they have to make changes to it. They can go ahead and keep that updating going instead of waiting a year and going through a lot of it, administration and a lot of, confusing times for people and applicants and staff by not being able to amend your zoning ordinance. So it's something to keep in mind for the majority of the states with town form of government, is that the zoning amendment process is long and it's hard. It can be confusing. So keep in mind that you don't want to present too many zoning ordinance amendments at once for town meeting, okay? Because your zoning amendments are going up with election officials, so you don't want to overwhelm people. And that's kind of one of the downfalls that towns have versus cities, and when it comes to zoning amendment time, is that you can't overwhelm people with zoning amendments. So when you're going through and speaking with the ZBA and speaking with staff and looking through your zoning ordinance, you really kind of got to whittle down and see what your top 5 or so would be for that year. Petition zoning amendments are zoning amendments that are submitted by 25 or more registered voters. The language for petition zoning amendment cannot be changed. So that is presented to the planning board as is. The planning board, as with all zoning amendments brought forward, they have to hold a public hearing. They can either recommend or not recommend its approval on the warrant. So planning boards are responsible. Again, the planning boards are kind of driving the bus for most of the zoning and the land use regulations, right? So they must hold at least one public hearing, like I said, for zoning amendments. And that's when, when you have controversial ones, you may want to start that zoning amendment process, or just, complicated ones, maybe not even controversial. But you want to start that process, as early as you can, because if you have, a public hearing and then you get a lot of public comment and changes, substantial changes are made to that, you have to have enough time to hold that second public hearing. So trying to, start that process early on. And the noticing process is for planning board hearings. It's according to 675 7, the requirements for the noticing of public hearings. And NHMA and our office, we put out our zoning amendment calendars every year for all forms of town, all town forms of government for the time of year, traditional March, SB2. March and May and April. So make sure, we all know that the zoning amendment, like I said, the zoning amendment process is really administrative intense. So you have to make sure that you're posting things in time, because if you miss a day of posting, then that whole zoning amendment comes off the table. So, our amendment calendars are available online now. And if you have any questions again about noticing, about zoning amendment calendars, the time of year, when to start hearings, feel free to reach out to us and NHMA. Next slide. So we're going to get into the nuts and bolts of zoning ordinance. So I'm going to review briefly just some basic kind of standard and outline of what a zoning ordinance should have. Next slide, Noel, please. So the ingredients for a traditional zoning ordinance. So there are elements that should be included in every zoning ordinance in order to clarify, identify, and preserve its legal standing. Okay, so again, this is your rule book. So if someone's going to challenge your rule book or the rules in your rule book, you need to make sure that you've got the legal standing to do that, and that things are identified and clarified, codified for your legal standing. Okay, so your title is important. You can use your authority. I've seen it a few different ways, the authority or the preamble. Again, that's the specific state and that enabling provision that makes this rule book legal for the community to do. So the wording can be a little bit different. And again, depending on how you're calling it, whether it's your authority or the preamble, but there should be there for your legal standing. Next slide, Noah. The purpose statement, that's to codify the community's reasons for adopting planning. And again, you know, just stealing the language from a purpose. This chapter is made in accordance with the Pembroke Master Plan and is designed to lessen congestion in the streets, which was a goal of zoning, to secure safety from fires, panic, and other dangers, protect public health and health safety, promote health and safety and the general welfare of citizens, to provide adequate light and air, to prevent overcrowding of land and to avoid undue concentration of population, to facilitate the adequate provision of transportation, solid waste facilities, water, sewage, school, parks, child daycare, and assure proper use of natural resources and other public requirements. So again, it's kind of this mixing and combining planning and zoning, because that's kind of what we talked about, what the master plan is, you know, the goal of the master plan. We also talked about that's what zoning is. Zoning is the ability to regulate what goes where and how much and how often. And this, again, creating your purpose and your standing with your rule book this is how you should follow through with that. The applicability, again, is, you know, for your legal standing. The requirements that says basically that this ordinance shall apply to the entire community. And you also need to have, for, you know, legal purposes, you know, your severability clause or your savings clause that says if at least, you know, one section of this ordinance is challenged, or, you know, a town gets sued over one section of an ordinance, that doesn't mean that the whole ordinance is invalidated. So these are, again, some things maybe you want to, you know, consider with your town attorney, whether or not your ordinance, you know, is meeting these requirements or it has the proper language for that. Because again, this is your rule book. And if someone challenges your rule book and your rule books, you know, don't have the appropriate or adequate rules enabling them to have this legislation or these regulations, then you could lose that case. So just make sure that your ordinance doesn't have to have this specific language, but just give your zoning ordinance a cursory review to say, yep, we have applicability, we have severability, we have these components. Next slide, Noah. One of my favorites, as you know, definitions. Again, definitions are really important to have in your zoning ordinance because it lets people know what uses are, what's expected of them. So you should really spell out your definitions in this section here, in addition to listing all of your definitions, but you need this, this explaining language so that people understand how a certain term is going to be used. And when in doubt, if you can't figure out how to define a doggy daycare, then the best thing to do is to go to the dictionary, get your rule book, plain language that everyone in the community can hopefully understand, or the layperson language. Definitions shouldn't be filled with legal definitions or technical, wording that makes it hard for the general public to try and understand. This is the community's rule book. So if you're coming across uses, or you need to change a use or a definition and you're not sure how to define it, the good old standard is to use the dictionary. Next slide. Zoning districts, again, another example of what communities should be including. You should really be defining your districts. It's another important one because it helps, as Jennifer, introduced us to zoning ordinances. You usually have, your standard residential, commercial, industrial kind of districts, but there really should be some kind of description with that, again, for the legal standing for your rule book, to make sure that you're using, if we create an agricultural district, and why did we create this agricultural district? To ensure agricultural, growth, and to promote and allow agricultural farm stands and farmers markets. Then you make sure that those definitions of the district, the description of the district, matches the rest of your zoning ordinance, so that that when you read what is expected in the agricultural district, you go to the table of permitted uses and you'll see farm stands and hay rides and corn mazes. So it's important to make sure that your rule book kind of describes what those districts are for and the purpose of them, and then your uses kind of fall into those districts. Next slide, Noah. Again, a few more examples of different districts where you have resort commercial, where this provides land for tourism, support services, and residential use. So when you look at residential commercial district and your zoning map and in your table of permitted uses, you would see there's restaurants, there's arcades, there's movie theaters, different kinds of uses. It's important, again, for your rule book to be descriptive as possible and to make clear what the purpose of each district is. Next slide now. So now we have what base districts versus overlay districts. So what is a base zoning district, as we've been talking about? So a base zoning district, again, sets the standards and describes the uses that are allowed in that area and the purpose and intent of that district. Again, we're talking about basic zoning districts. You can always have more, like we just talked about, but your basic districts are your residential, commercial, rural, recreation. So those are all your standards and your guidelines of your single family residential district is allowed over here. Overlay districts is a defined area through the map and ordinance where certain individual requirements are supplemented on top of a base zoning district. So you may have an aquifer protection overlay district. You may have wellhead protection, parking overlay district and business districts. So these overlay districts are in addition to the requirements of your base district. So we're in downtown Manchester, and obviously there's businesses, there's restaurants, it's an old city. So obviously those cities can't meet parking requirements as if I was building a brand new restaurant on a vacant lot. So the city may want to, put in an overlay district for parking so that you can describe that doesn't have to meet the exact regulations for parking, but parking is allowed generally, or for an aquifer wellhead protection area. Again, so your base district has certain rules, regulations, uses that are not allowed. You put an overlay district on top of that, then there's additional uses that have to, additional requirements that have to take place because you have this overlay district. It's not one or the other, it's another extra layer of regulating the lands, whether it's sensitive or can't meet current zoning. Those are the ideas for overlay districts. And hooray, table of permitted uses, right? Love talking about the table of permitted uses. So within each zoning district and indicated on the official zoning map and subject to all requirements and conditions specified in this ordinance, land, buildings, structures shall only be used, and buildings and structures shall only be erected which are intended or designed to be used for uses listed in the table of permitted uses. Okay, so again, if I want to put in a nuclear power plant in my town and it's not listed in the table of permitted uses, I can't do it without a variance, but generally speaking. But it's important that you have to spell that out to people. So number 2, when a use is not listed in the table of permitted uses, the zoning administrator shall classify it with that the use in the table most similar to it. If there's nothing, similar to a nuclear power plant, or, I want to put in a merry-go-round. Okay, so there's nothing similar in the zoning ordinance of the merry-go-round. The next step would be, is there anything similar to a merry-go-round that could fit into the description of the zone or the definition? And if not, then that use is prohibited. So it's important, again, to make sure that your table of permitted uses is specific and matches with your definitions, so that there isn't a lot of loose interpretation, as far as, is it a merry-go-round, is it a not merry-go-round, doggy daycare, is it not a doggy daycare? So your table of permitted uses should be matching your definitions, and vice versa. Next slide. So these are some examples of table of permitted uses. Again, this is your rule book. It needs to be user friendly. Just open up the page to table of permitted uses. I can easily find in the residential zone that single family is allowed. If there's special conditions to it with multifamily, open space uses. So again, it's user friendly, and it describes at a glance what is permitted, what's permitted by special exception or conditional use permit, or something that's not permitted. Next slide, Mel. Dimensional regulations, again, one of the cornerstones of zoning that we're learning, right? That the community is able to regulate dimensional requirements, size, height, location. So you can see again that your dimensional requirement table, that if you have, depending on what type of lot it is, if it's in the city and it has sewer and water, then the requirements for a new lot would be less than if there's for a lot that's out in the country that doesn't have sewer or water. So again, these are based on, each individual zone or the district and the uses being proposed. Next slide, Noah. So again, your rule book, right? So the rule book, we need to know who's in charge, who's responsible, who's making the enforcement, who's charging the penalties, right? So again, these are things that if the rule book, if the rule book doesn't explain who's in charge, how the enforcement proceedings go, what are the penalties for breaking the rules, then that can be challenged, and then you're going to run into situations where the town's going to lose out or a property owner is going to lose out. Because there isn't laid out, the rule book isn't clear. So you should make sure that your administration, your enforcement, your penalties section of your ordinance are pretty clear, that it's the selectmen that are, the administrators who can then turn around and grant that power off to the building inspector, the code enforcement officer. The code enforcement officer is responsible for enforcement. There's a procedure there for how zoning enforcement should move forward. There should be also outlined for what your penalties are, so that, again, it's your rule book. If someone breaks the rules, you need to have a process. You need to have it spelled out so that people understand what's expected of them and what will happen if they break the rules, and who's in charge. Next slide, please. So again, some ingredients again for a traditional zoning ordinance. Every zoning ordinance needs some kind of relief, right? While the courts have ruled that towns have the ability to implement zoning, the United States Supreme Court has said that towns have the ability to regulate within their boundaries to create zoning. They've also said that you can't have a rule book without some kind of relief. Okay, and that relief comes in the form of a variance. So the variance is the authorization of a use which is otherwise prohibited by a zoning ordinance. Okay, it's relief granted by a zoning board of adjustment from the literal and strict application of zoning regulations. So the ZBA, they are giving you a permission slip to, I want to build my merry-go-round. Okay, I go to the zoning board of adjustment. It's a prohibited use because they're applying the literal strict interpretation of the zoning ordinance. Say, no, Stephanie, a merry-go-round is not allowed in your neighborhood. So I then apply for a variance. You have to go through the criteria of hardship for a variance, but it's important because legally it gives that person that relief valve, that relief that I want to do something with my property. When I want to build a house, my house is small. There's a lot of wetland. There's a lot of rock outcrop. I can't meet current zoning regulations. So I would need a variance. I would have to prove a hardship to the zoning board of adjustment. And that hardship would be something inherent with the land. So that if the strict application of zoning saying that, Stephanie, you're in this zone, your house needs to be 35 feet away from a property line, okay? That's interrupted by rock outcrop or the buildable area or the lot, the way it's designed. You know, I can only really build a house, 20 feet away from the property line because of this inherent feature with the land. So therefore that variance is granted upon that particular lot. It stays with the land. But again, it's that relief valve, because if it wasn't there, then the community, the government would be taking away my ability to have any type of use with my property. Doesn't necessarily have to be the best use of the property or the use that I want the most of the property, but you can't have regulations that don't provide any kind of relief valve. If I want to build my house with a 4-car garage and I want a variance because my 4-car garage won't fit on my lot, that's not really a hardship because I can have a 3-car garage or I can have a 2-car garage. But because I want a 4-car garage and I want to put it 10 feet from the property line when the setback is 20, that shouldn't be grounds for a variance because I'm still getting use out of my property. That's not a taking. And that's the way that variances should really be looked at. It's really case specific. It should really be something inherent with the land. And if the property owner wants a 24-foot deck and that's going to violate the setback by 10 feet, I think they could probably live with, a 14-foot deck. So it's in order to provide relief and not get into a taking situation. Next slide. We're on break. Okay, so thank you. I will, if you wanted to, are there any questions, Ashley, so far at this point from the first section here that maybe we could take, or if people want to take a break, it's up to you guys what you would like to do.
So it doesn't appear that you have any questions.
Okay, great. Well, then we'll have a break.
Yeah, I think we can take a break for everybody.
Sure.
How long of a break?
I would say about 10 minutes or so, 10 to 12 minutes. It's
okay.
After 11. Right. So.
Okay, so it's 11:17. If we're doing a 10-minute break, then I ask that everybody come back and join us or pause their video screen and come back and join us at 11:27, please.
Great, thank you.
We'll give it one more minute and then we'll go ahead and get started again. Great, so we're going to go ahead and get started. Welcome back, everyone. My name is Noah Hodgetts. I'm a principal planner at the Office of Planning and Development within the Department of Business and Economic Affairs, primarily working in our municipal and regional assistance program with Stephanie. So now that Stephanie has outlined what is in a traditional ordinance, I'm going to briefly discuss zoning's relationship to other land use regulations. As previously mentioned, the first step in developing community-based land use regulations is for the community to vote to create a planning board. Once a planning board is created, one of their first jobs, as Stephanie has mentioned, is to create and adopt a master plan. The master plan is the required legal building block for the creation of all land use regulations and provides the legal standing for the community to create and implement them. Creation of a planning board and master plan not only gives a community authority to adopt zoning, but doing so also provides the planning board with the authority to adopt several other land use regulations and controls listed on this slide. Land use regulations are how a community plans for growth and development in the future and are based on the development goals and objectives of the community as outlined in the master plan. While we think of ourselves as a home rule state, we are actually, in fact, a Dillon's rule state, which means that in New Hampshire, local jurisdictions can only adopt regulations, including those having to do with land use, which the legislator has expressly given them the authority to enact. While it's possible for a community to adopt subdivision regulations, a capital improvement plan, excavation regs, regulations and driveway regulations without having zoning, as all but 2 of the 19 non-zoning communities have done, primarily through subdivision regulation. Zoning is the framework which ties all these land use regulations together and allows them to work to the maximum degree. For example, a community without zoning may have residential subdivision regulations which address street layout, lot and site configuration and utilities. But without zoning, it's difficult to regulate other things such as density and height, or where subdivision can or cannot be located. Furthermore, without zoning, it's impossible to restrict or prohibit noxious or offensive uses of property. We've seen this most recently up north. There was a proposal, as some of you may know, for the siting of a landfill in the town of Dalton, which did not have zoning. There was a process to enact a temporary emergency zoning ordinance under statute, which by law was allowed to be in effect for 2 years in order to try to prevent or slow down the process of this landfill being sited there. There was then a process to enact permanent zoning in that town, which ultimately failed. Again, out of all trying to kind of really started with trying to prevent or restrict the ability to site this landfill. And so again, without having zoning, it's really hard to restrict those kind of could be thought of as more kind of potentially offensive uses or uses that could have create a nuisance for certain people. So as shown in this slide, the process for adopting different land use regulations can be complicated. As previously mentioned, a planning board and a master plan, which guides the future development of a municipality, are both required to adopt other land use regulations. Adoption of site plan regulations, as Stephanie highlighted, not only requires zoning, but also requires adoption of subdivision regulations, while administration of impact fees requires the adoption of a capital improvement program. Now, as Stephanie touched on a little bit, and again, some of these things you just need to kind of, doesn't hurt to reiterate over and over. Unlike zoning, which can only be adopted or amended by the local legislative body once a year at town meeting, unless you're in a city or a community with a town council, for nearly all other land use regulations overseen by the planning board can adopt changes or amendments anytime it sees fit at any time of year after holding a public hearing on the matter. In practice, this often means it's a lot easier to amend subdivision and site plan regulations than it is to amend the zoning ordinance. While RSA 674:16 grants cities, towns, and counties in which there are located unincorporated places broad power to enact zoning ordinances if they promote the health, safety, and general welfare of a community. This power is not unlimited, and it's important to be aware of the several state and federal statutes which have placed limitations on the zoning power. Over time, the legislature has chipped away at municipalities' authority under RSA 674:16 to prohibit, regulate, or restrict different land uses via zoning through enactment of different state preemptions. Most recently, this past legislative session, through the passage of HB 1021 has caused land uses and structures which are used primarily for religious purposes to be exempt from zoning. While we don't have time to go through the specifics of each preemption in detail, the preemptions listed on this slide restrict, among other things, the ability of municipalities to zone out or prohibit attached accessory dwelling units, agricultural uses, including the tilling of soil and the growing and harvesting of crops, the regulation of campgrounds, including densities of camping sites, either tents, recreational vehicles, or cabins, and the type of sanitary facilities that are necessary for campgrounds. State preemptions also restrict or state that zoning cannot unduly regulate commercial and recreational fishing operations. State preemptions have also placed limits on applicability to government land uses. As well, there's also state statute which speaks to siting of energy facilities, including renewable energy facilities, which have a rated capacity of 30 or more megawatts. Again, zoning has limited power in the restriction or siting of those uses. For energy facilities over 30 megawatts, those are fall to the jurisdiction of the Site Evaluation Committee, the SEC. State statute also restricts zoning's ability to prohibit or restrict manufactured housing on individual lots or in manufactured housing parks. As I just cited, the House Bill 1021 passed this past session restricts the siting of a restriction of the siting of both primary religious land uses as well as structures in zoning. There's also state statute which restricts or prevents zoning's ability to restrict the siting of small wind energy facilities with a rated capacity of not more than 100 kilowatts. And finally, the workforce housing statute restricts where zoning's ability to restrict where workforce housing, defined as rental housing, which is affordable to a 3-person household earning 60% of the area median income, and housing which is intended for sale and is affordable to a 4-person household earning 100% of area median income, where workforce housing can be cited, or whether a zoning ordinance can actually restrict or prohibit workforce housing altogether. The government, I guess one other note here is that the government land use preemption under RSA 674:54 goes even further than only restricting the ability of zoning to actually regulate these uses or state where they can and cannot be located, but it actually, in fact, exempts all federal, state, county, and local government land uses from any land use local land use regulation, including zoning. And so these uses, a government entity still needs to notify the planning board of the existence or plans for a change of use for any government land use, and the planning board can comment, but it doesn't actually, by and large, if a government entity is asserting a change of use for a government land use, it can do so largely outside the confines of land use regulations and zoning that every other use would typically have to follow. So now that we've touched on some of the state preemptions, I'm going to talk a little bit about some of the federal statutes, which can also limit what a community can regulate in zoning. This list is really just a few statutes which kind of relate directly to land use. There's obviously a lot more statutes which can come into play when a development is going through the review process that I'm not going to speak to today. So the first statute I'm going to talk about is the Natural Gas Act of 1938, which doesn't come into play very much here, but as interpreted by federal courts, does prohibit a community from zoning out interstate gas pipelines. Next statute, which generally can restrict zoning, especially as it relates to housing, is the Federal Fair Housing Act and subsequent amendments, which prohibit discrimination in housing for several protected classes, including race, color, national origin, religion, sex, familial status, and disability. The courts have made clear that this prohibition extends to zoning, which blatantly seeks to exclude persons of specific protected classes. However, I'll note that has not stopped the good chunk of communities from trying to craft overly restrictive zoning, which while not naming any of these protected classes specifically, has the intended effect of seeking to exclude persons belonging to certain protected classes. And I will just say that this is a kind of, you know, hairy, kind of gray area, and that communities really need to tread lightly if they're trying to exclude persons of protected classes through exclusionary zoning without actually naming them, and that doing so could potentially open them up to cause of action or lawsuit alleging violations of the Federal Fair Housing Act. And so you really got to be careful here. The next statute is the Americans with Disabilities Act, better known as the ADA, which extends the protections of disabled persons in housing to all entities providing public accommodations, including private businesses that provide goods and services to the general public, as well as commercial facilities, which are generally defined as privately owned, non-residential facilities whose operations affect commerce, but who do not serve customers or clients. Think of those as kind of facilities such as warehouses, factories, or corporate office buildings. And its extension of the ADA requires policies, practices to these facilities, requires policies, practices, or procedures when the modifications are necessary to avoid discrimination on the basis of disability, unless the public entity can demonstrate that making any of these modifications would fundamentally alter the nature of the service, program, or activity. Again, the applicability of the ADA is pretty far-reaching, to the point that it's not uncommon to see a community say, usually not in zoning, but more typically in site plan regulations, that a applicant not only has to adhere to all of the conditions set forth in the site plan regulations, but also has to, in order to get their site plan approval, also needs to agree to adhere to ADA guidelines. And in terms of zoning, this means that a community cannot implement an overly restrictive zoning scheme, which would prohibit the kind of ability to accommodate or convert a building into kind of addressing any disability or accessibility concerns. This could, for example, look like, zoning could not restrict a commercial building, for example, from installing an elevator in order to make the building handicap accessible in compliance with the Americans with Disabilities Act. There's a number of other examples where this could come into play, or situations where this could come into play as well, but just something to be, good thing to be aware of. The next federal statute, which often comes into play and can restrict a municipality's ability, municipality zoning power and its ability to enact local land use regulations, is the Telecommunications Act of 1996, better known as the TCA, and subsequent amendments, as well as FCC orders, which have expressly placed substantive and procedural limits upon the authority of communities to exercise their planning and zoning power when exercised in relation to personal wireless service facilities, better known as PWSFs. Otherwise, in more layman terms, cell towers. And this power is especially the ability of a community to zone or restrict where cellular communication towers can be located, is especially restricted when a community is not already served by a cellular provider. RSA 12K goes even further and mirrors a definition of personal wireless service facilities found in the TCA by setting out a standard process for citing co-location and modification of PWSFs. And taken together, the TCA and RSA 12K prohibit communities pretty much from outright banning construction of wireless cellular communication towers. The last federal statute I want to touch on here is the Religious Land Use and Institutionalized Persons Act of 2000, which protects the free exercise of religion guaranteed by the First Amendment from government regulation by prohibiting zoning ordinances and other land use regulations that unduly burden or discriminate against religious institutions. Put simply, a community cannot subject religious institutions to more restrictive zoning regulations they would to other land uses. And as I previously mentioned, House Bill 1021, signed into law this past summer, goes even further than the Religious Land Use and Institutionalized Persons Act, RLUIPA, by effectively exempting applicants who are asserting that their land use or structure is a primarily religious use from zoning. However, the new law does still permit site plan review of primary religious uses that is limited to controlling the height of structures, yard sizes, lot area, setbacks, and building coverage requirements, provided such requirements apply equally to non-religious and religious uses, and again, do not substantially burden religious exercise. But again, this the House Bill 1021 does go as far as basically really allowing any primary religious use to be allowed in any zone, and restricting the ability of a planning board when going through the site plan review process from really looking at any issues like parking, lighting, noise, other performance standards that it might typically look at during the site plan review process. And so again, I don't think it can be overstated how far-reaching the effects of House Bill 1021 really are. Now that we've touched on some federal statutes that preempt or restrict the ability of communities to zone, we're going to talk about some other state regulations and permits which can also affect local zoning in the location and intensity of development. So this is, again, not necessarily a fully extensive list. I think I've covered the big ones, but there could be other state statutes that come into play during the development process. But I'm gonna highlight a few here. So alteration of terrain permitting is focused on erosion and sedimentation controls and this is administered by the Department of Environmental Services, Land Management Bureau, DES. And AOT permitting applies to any large-scale development greater than 100,000 square feet or 50,000 square feet of shoreland area, as well as disturbances of greater than 2,500 square feet of terrain, having grades of greater than 25%. Next statute on the list here is the Endangered Species Conservation Act, administered in part by the Department of Fish and Game, which protects the habitat of endangered species from development. Next statute, which actually I think was talked about a little bit in the earlier session that Attorney Michael Klass spoke about on the Housing Appeals Board, is RSA 674:41, which establishes minimum road access requirements, including some frontage requirements, and regulates the 5 types of streets that buildings can be erected on. The next set of state statutes to be aware of is RSA 485-A, which lays out the permitting requirements for septic systems by the Department of Environmental Services, and requires not only tasks the Department of Environmental Services with permitting septic systems, but also lays out a process for state required approval for subdivision of lots smaller than 5 acres that are not served by public sewer. The Shoreland Water Quality Protection Act, RSA 483-B, also limits development within 250 feet of public waters, including lakes and ponds greater than 10 acres, streams and rivers, and coastal waters. again, this would kind of, you could think of it as almost being like a overlay above a community's base zoning. And so a community could say that certain uses are allowed within, say, commercial use is allowed within a district, and the district happens to be traversed by a river or a stream, then automatically, whether usually not necessarily listed in the zoning ordinance, that development is basically very restricted, or really there really is no development allowed, or with a few exceptions within 250 feet of that river. And then the zoning would apply as well in that case. But it's just good to be aware that it isn't just the zoning alone, which is going to dictate where land uses can and cannot be located. There's this whole other kind of state scheme of state statutes which need to be considered as well. A few other statutes to be aware of are the State Building Code, RSA 155A, and the State Fire Code, RSA 153. State Building Code regulates how buildings are constructed through structural strength, means of egress, facilities, stability, sanitation, and adequate lighting. The State Fire Code dictates the location of fire doors, fire suppression systems, frequently usually sprinklers, as well as the location of emergency egresses. And then just one or two more. State driveway permitting by the Department of Transportation, DOT, includes the permitting of driveways on all state roads based on site distance to provision of adequate access and maintenance of safety along the corridor. Again, this is a separate process in addition to the local driveway permitting process that a community may have. And then in terms of historic preservation, RSA 227C sets out a process for historic preservation review by the New Hampshire Division of Historic Resources to ensure the protection of designated New Hampshire historic landmarks, as well as compliance with Section 106 of the National Historic Preservation Act when federal funding or permitting is involved. And finally, regulation of wetlands is laid out in RSA 482 -A, which requires permitting of wetlands when excavating, removing, filling, dredging, or constructing structures in or adjacent to any bank, flat, marsh, or swamp. And again, this permitting process is administered by the State Department of Environmental Services, DES. And as we'll talk about in a minute, there is some communities have decided to go even further than these state statutes and administer their own kind of local versions of some of these state statutes that we will get into in a minute. I think actually on the next slide. So despite the many federal and state statutes which have placed limits on what communities can regulate, restrict, or prohibit by zoning, as I've just touched on, there are many other planning and development tools, techniques, and regulations besides the nuts and bolts Stephanie discussed earlier, which are typically found in traditional zoning ordinances. These include regulations pertaining to accessory dwelling units, adult-oriented businesses, age-restricted housing, so senior housing, architectural design standards, cluster open space subdivision. And then we get into a couple of things here, which I said, which in some cases go beyond the state statute. So some communities have included their own drinking water protection ordinances, groundwater, aquifer protection ordinances, surface water protection ordinances, watershed protection ordinances, wetlands protection ordinances, which go beyond the minimum state requirements that I outlined in the previous slide. Other kind of regulations which are frequently found in the zoning ordinances, in the zoning ordinance, are floodplain protection ordinances, which are required for any national flood insurance protection NFIP community or community participating in the NFIP program, historic district ordinances, impact fee ordinances or regulations having to do with impact fees, outdoor lighting, shoreline protection, sign regulations, small wind energy systems, solar energy systems, steep slopes, ridgeline protection, stormwater management, wireless telecommunications, and workforce housing. And again, this list is not meant to be all-inclusive. Generally speaking, if particular use is not restricted by one of the federal or state preemptions that I discussed previously, municipality, if it so chooses, can enact regulations and or performance standards in its zoning ordinance for any use that it's previously defined in its ordinance and or listed and or that's also listed in the table of permitted uses. So again, if a community is really concerned about or thinks that there could be an issue with, say, racetracks, for example, and racetracks are a permitted use, say, by conditional use permit in certain zones. It could then lay out, have a section on racetracks, which regulate everything from time that the racetrack is allowed to be open and operational to the noise level and decibels that the racetrack is going to be allowed, cannot exceed, things along those nature. And that could go for any number of uses. So this list is really kind of a good baseline list of what uses or regulations you should have in a zoning ordinance, but it's by no means the be all end all. We've seen it all here. So this is all more or less to say, you can think broadly. As long as the as long as the use is not restricted by any of the federal or state preemptions that I've discussed, 674-16 really gives pretty broad authority for a community to regulate any use in zoning. So now that we've covered the history of zoning, the nuts and bolts of a zoning ordinance, state and federal preemptions, and other regulations to consider and that are typically found in the zoning ordinance, we're going to talk briefly about the future of zoning in New Hampshire and what that looks like, or what that could look like. So I think that Stephanie may have mentioned it a little earlier, but communities that have adopted zoning under RSA 674:16 also have the broad authority under RSA 674:21 to adopt innovative land use controls, including timing incentives, phase development, intensity and use incentives, transfer of development rights, planned unit development, cluster development, impact zoning, performance standards, flexibility, and discretionary zoning, environmental characteristic zoning, voluntary inclusionary zoning, and village plan alternative subdivisions. There's a very long list of 14 different tools. These tools typically are detailed in the zoning ordinance, but allow more flexibility than traditional Euclidean use-based zoning. We don't have time to go into each of these tools in detail, but for example, planned unit developments, PUD, are a flexible, non-Euclidean zoning device that redefines the land uses allowed within a certain area. They typically integrate a mix of compatible building types, land use, and densities within a single parcel or across several parcels. The best way to think about this is, if you may remember back at the beginning of our presentation, Jennifer talked about the difference between kind of traditional use-based zoning and more mixed use zoning, or this kind of shift to more mixed use zoning. And so PUDs, among other things, really allow this kind of more mixing of uses, getting away from the typical Euclidean segregation of uses, separation of residential from commercial, from industrial. And some of the best known PUD examples in the state, or some of the largest ones, are located on several hundred acres of land, including Tuscan Village in Salem, Woodmont Commons and Londonderry and West End Yards and Portsmouth. But while these are kind of some of the most iconic examples, due in large part to their size, there's no reason that PUDs or mixed-use zoning cannot be used to create lower density mixed-use walkable developments that fit in with the character of our more traditional village centers found in smaller suburban and rural communities throughout the state. 674-21 also grants broad authority to communities to adopt land use controls not listed in the statute. And so, you know, examples of some of these kind of innovative land use schemes that are that have been created under the guise of the innovative land use statute include schemes which seek to address the state's growing aging population and need for additional housing, including Chester's adoption of an age-friendly subdivision ordinance, which allows smaller dwellings at higher densities and on smaller lots than would typically be allowed in traditional subdivision, and Dover's passage of an ordinance which explicitly couples permitting of new commercial developments with housing. So I don't have specifics on hand, but basically based on the size of a commercial facility, how big it is, how many people it's going to, people are going to work there. When a developer goes for a permit for a commercial facility in Dover, they also basically get a permit for a certain number of housing units that are affordable at HUD limits. And so it's kind of basically seeks to create this explicit link between commercial development and housing development. These are just a few of kind of the innovative statutes that communities have sought to enact under the innovative land use control statute, which again, really kind of when layered on top of 670, the zoning power given to communities under 674-16, really allows for communities to do a very, you know, control, restrict, allow land use under a really kind of wide range of tools. And so I just encourage anybody on this webinar viewing this session right now, who may either be on a planning board, zoning board, be a town planner, to really think about kind of innovatively, kind of really think about what are the kind of what are ways to really kind of push the limits and kind of think differently about how to regulate land use and do things in a more innovative fashion. And so with that in mind, as attorney Brett Allard wrote in a recent article titled The Past, Present, and Future of Zoning, we may never nor wish to completely shed Euclidean zoning in our lifetime, given its deep roots in American planning philosophy. But the future appears to be on track for more flexible land planning to support and facilitate inevitable population growth and the appetites of modern citizens. The broad flexibility contained in RSA 674:21 means that it's not unlikely that we will see communities in the near future adopt other innovative zoning tools which are at the forefront of planning nationally, such as pattern zones. Hasn't been done yet in New Hampshire, but I won't be surprised if we see it in the near future, in which a municipality provides licensed pre-approved building designs and plans, typically along with an expedited permitting process for a specified area. So basically in practice, this basically mean that the planning board pre-approves a menu of building plans that a developer applicant can pick from. And then since they're already pre-approved, they could then, in order to actually be built, they could be approved through an expedited permitting process, which could then, could help to speed up the very long drawn out permitting process that we typically hear developers complaining about experiencing at the local level here in New Hampshire. Another kind of innovative tool that you're starting to see nationally a lot more and more is zoning targeted to encourage the production of missing middle housing that is multi-unit, but still at the scale of houses, which is intended to be part of low-rise residential neighborhoods. So communities, so those are just a few kind of examples of innovative land use controls, but still that are kind of within the confines of Euclidean zoning. Communities that want to go even further and take an entirely different approach to separation of land uses than traditional Euclidean zoning, or are looking to remedy the fact that many of their buildings and lots cannot be rebuilt under their current zoning ordinance, might want to consider creation of a form-based code. Form-based codes regulate land use and development with a focus on the character and physical form of an area rather than the use of the buildings and separating uses. The code considers the visual impact of buildings, parking, and the public space, such as sidewalks and streets. Greater emphasis is placed on character, building features, and the public space rather than traditional zoning's emphasis on use of buildings. A form-based code is a regulation, not a mere guideline adopted into a city or town law, like a zoning ordinance is. As shown on this slide, form-based codes often divide a community along a transect from less to more development, and they also tend to, these are just, the picture on the right is from a kind of general kind of guide on form-based codes. Picture on the left, I believe, is actually from a form-based code in New Hampshire. I think this may have been, I think I took this one from the city of Dover, if I'm not mistaken. And so in that note, in New Hampshire, again, under the enabling authority of the Innovative Land Use Statute, RSA 674-21, a handful of communities, including Dover, Keene, Enfield, Lancaster, and Portsmouth, have adopted form-based codes for their downtowns or their entire community. And actually, in the city of Concord, I'll also note, is been working on the development of a form-based code over the last 3 years, and hopefully that will also get adopted in the next year or so. So now that we've talked about a lot of different kind of innovative or other ways of kind of thinking about zoning or zoning tools that communities can adopt, I just want to talk about a few tools that are tools and resources that are available for communities interested in adopting or updating their zoning, or kind of thinking about kind of wanting to include more of these kind of innovative practices in their zoning, but feel like they might not have the capacity to do so themselves, or looking for examples that they can of these innovative practices that they could adopt into their own ordinances. So for communities that do not have zoning, as well as those that are interested in better aligning their zoning with their master plan, or addressing the realities that many communities throughout the state are facing, including aging population, and insufficient amount of housing, and climate change, these are a few resources and tools for you. First, on the top of the list is the Invest NH Housing Opportunity Planning Grant Program, the HOP Grant Program, which is the $5 million program that was part of Governor Sununu's $100 million Invest NH Housing Program that he's funding from the American Rescue Plan. And so specifically the Invest NH Housing Opportunity Planning Grant Program, the HOP Grant Program, which you can find more information about at nhopgrants.org, provides grants of up to $50,000 to communities to review and audit your zoning and other land use regulations, as well as up to $100,000 to draft zoning or other regulatory changes which remove barriers to housing development. Again, this program is really geared towards auditing regulations and proposing new regulations to either remove barriers to housing development or expedite the housing development permitting process. But it is kind of an unprecedented level of funding out there. Again, it's part of a $5 million Invest NH Municipal Planning and Zoning Program. And communities that are interested in applying to this program but don't have a consultant they'd like to work with in mind, the New Hampshire Housing, Plan New Hampshire, and UNH Cooperative Extension, which are administering this program, had developed a list of qualified HOP grant consultants that can be found by clicking on the link on the slide. I just want to remind folks that no community is too small to apply to this program. And actually, as a member of the steering committee for the HOP grant program myself, I can personally attest that staff involved with this program are willing to review proposals in any stage and that might not even be fully baked or is still in the conception stage. And so, we've started to get some applications for this program, but I just encourage all of you to go back to your communities, spread the word about the existence of this program. And to learn more, you can go to nhopgrants.org, or you can click on the URL and the PDF of this slide, which should be available for download on WOBA. The next resource I want to highlight briefly is the Resilient Land Use Guide for New Hampshire, which was released this past summer, which is a partnership between the Rockingham Planning Commission, the Stratford Regional Planning Commission, with support from the New Hampshire Department of Environmental Services Coastal Program. And this guide contains a set of land use model regulations and best practices that incorporate updated information to help municipalities in New Hampshire adapt to climate change and coastal hazards. Again, it's, these are model regulations that are kind of, if your community is interested in adopting or having your zoning address anything from, stormwater management to flooding to coastal erosion, this is a great guide to find model regulations and examples for how to do that how to amend your own zoning ordinances and other land use regulations to do just that. And then a few other resources I just want to highlight before the end of our session is my office's OPD's Municipal Land Use Regulation Survey website, which provides a wealth of information on the type of planning and zoning tools employed by communities throughout the state, as well as tables with links to each community's zoning ordinance and other land use regulations. The interactive map feature of the website is especially helpful for communities looking to see what types of innovative land use controls and other planning and zoning techniques communities around them have adopted. We're nearly finished on the 2021 data, and this is going to be posted on our new website, which, as I think Jennifer mentioned at the outset, we're still kind of transitioning from our old OSI website to our new BEA website, but hopefully that'll be up in the next, hopefully before the end of the year. And so with that will come the release of the 2021 data. And then next resource I want to quickly highlight is the New Hampshire Zoning Atlas, which is a collaboration between the St. Anselm College Center for Ethics and Society, New Hampshire Housing, and our office, the Office of Planning and Development, and is part of the National Zoning Atlas projects, which will be a database and interactive map cataloging portraying district level zoning affecting housing construction across the entire land area state. The data will initially be valid as of June 1st, 2022, and represent zoning and other land use regulations which affect housing that municipalities have adopted. The New Hampshire Zoning Atlas is tentatively scheduled to be published in December 2022. The link on the slide goes to a kind of general informational page about the atlas, but that page, and once the zoning atlas is published, we'll be sure to put up additional information about how to use the zoning atlas, and we'll be sure there'll be additional publicity about the zoning atlas as well from the different project partners. And then finally, the last resource I want to highlight, while 14 years old, the 2008 Innovative Land Use Planning Techniques Guide, a handbook for sustainable development, still contains many helpful examples and model regulations for communities interested in adopting one of the innovative land use controls in RSA 674-21. So we hope this presentation has provided a good overview of how zoning works in New Hampshire. With the few minutes we have left, feel free to put your questions in WOBA, and we'll do our best to answer them. If we don't get to your question now, or you have a more specific question, please feel free to reach out to Jennifer, Stephanie, or myself at the phone number or email address shown. Stephanie and I work in OPD's Municipal and Regional Assistance Program and can also provide guidance on any other planning and zoning matter you may have. So with that, Ashley, do we have any questions?
I do not see any questions, but I would encourage anybody now to type those questions into the Q&A if you have them, because we still have 6 minutes where you could do that if you wanted to. If not, what I'm thinking, guys, is that they were just taking all that great information in and processing it. So We can wait a few minutes just in case, because obviously, you know, some people, it takes some time to type questions in. So
Yeah,
we can give
sure.
it a few minutes, but if I, you know, in the next couple of minutes, if I don't see any come in, we can definitely, you know, be dismissed. So while I have everybody though, and while potential attendees could be typing in questions, I just want to say that beginning at 12:20 until 1 p.m., it will be lunchtime. So feel free to go grab a sandwich, do, you know, bathroom break, water break, all that good stuff. And we will reconvene at 1 o'clock for our next set of sessions. Let's see. Still doesn't look like we have any questions, but again, you know, 2 hours is a long time to listen to a great informational program. And, you know, just like Noah and Stephanie said, their emails are up on the last slide. So you are welcome to email them directly. Of course, you can also email NHMA registrations at nhmunicipal.org, and we would be happy to get any questions you have over to Noah, Stephanie, and Jennifer. So feel free to do that as well. And again, if you are looking for their emails once the slide disappears, you can find them if you go down below the video screen in Whova and down below the speakers, you will see their handouts. And obviously this final slide is in one of their handouts. So you do have access to their email addresses from there.
I want to take a quick moment to thank you, Ashley and Steve and everyone at NHMA for inviting us to your great land use law conference. We really appreciate it. We appreciate the collaboration. They're always fun and well done. So thanks again for including us.
We're really glad to have you. Thank you so much for your expertise today. It was really great. And so I don't see any questions. So I'll leave it up to you two. If you would like to keep waiting, we can. And if you would like to let everybody go and grab some lunch, we can do that as well.
Sure.
Okay.
There's no questions, and we can, break out early and grab some sunshine today, I guess.
Exactly.
Awesome.
Sure. Well, I want to thank everybody, especially our presenters today, for joining us. And we'll see you all at 1 o'clock. Thank you again, Noah and Stephanie. Have a great day.
Thank you so much.
Thank you, everyone. Take care.